He agreed that I'd do this.
What colour is he?
He's Labour.
Labour.
He's
okay.
a good bloke. He's all right. No, you know, I think sometimes MPs are seen to attack each other all the time. I don't think that really helps too much. I think there are a lot of really trying to do a reasonably good job. Graham's one of those, and I wouldn't be critical of him.
So, okay, so this went to which court was this now?
Well, it went to the Court of Appeal. Now, the thing about it is, in the Strand, you've got the Royal Courts of Justice. Mm-hmm. Some of the hearings there are High Court hearings, and some of the hearings there are Court of Appeal hearings. Okay. And it's important the level of the appeal. So here this mom says to the judges, and she puts forward quite a good case as to why she can instruct a solicitor, and they say, well, tough, no, you can't. All right? So... Yeah,
but she can talk to the judge and
talk to the judge and explain the case. And I've got the transcript and
of what she said.
Of what she said, yes. And I think if you read the transcript, which without the names, because the Court of Appeal is actually held in public but without names, so there's a reporting restriction, you'd say it's a bit odd. And in fact, if you met her, you'd find it's a bit odd.
Well, if I was her, I'd say, I'm sorry, I'm too stupid to pay tax as well.
Well, I know, but the point is, so we then took that after the House of Lords and they said go away. We then take it to the European Court, and the European Court's interesting because what they've said is, why couldn't she have a second opinion? So she had an expert paid for by the local authority.
Who are sort of kind of, you'd think, would probably be inclined if he wants another job like that.
Yeah, exactly. Well, this is the thing.
Give them
what
the
the judges don't
want.
spot is they have a system called the single expert system, where theoretically the appointment of experts by the court is a single expert jointly appointed by the parents and the local authority. The problem with that is the parents only face this once, and the local authority are in there every week, right? So obviously some of the experts, not all of them, are inclined to say what they want to keep getting instructions. Because if they don't say what they want to keep getting instructions, suddenly what happens is they find they don't get instructions. And, you know, if you get £5 per report, that's a lot of money. Right, so it may not take...
Yeah, and you've got the mortgage to pay, and
your kids
are at a nice school,
and it's sort of, well, it's all a bit difficult. You're too stupid to instruct a solicitor. You can't say no. Right? Now, the European Court has said, well, as a first starter for 10, why wasn't she allowed a second opinion? And there's an interesting case called X v Croatia, which looked at the issue of people having their capacity removed. Because obviously, if somebody's in a coma, they can't instruct a solicitor, can they?
No, they can't.
Right, so there's a question of who you put. Well, why should it be the official solicitor? Why couldn't it be her brother or a mum or a dad who had her best interests at heart rather than just rolling over and playing dead, which is what the official solicitors did? Now, that happens about 150 to 200 times a year.
What has this got to do with Croatia, though?
X v Croatia is another European court case also about mental capacity, where a mother's children were adopted. She was excluded completely from the process, and the European Court found against Croatia because they'd abused her rights. But in that case, she did have very serious problems, whereas in this case, I know the mother concerned, and you know, if you talk to her, we have a slight problem that she might be able to come on with names and everything, but there's a slight complication because it's in the European Court. That's changed the reporting restrictions.
There are different ones, are there?
They're different, and I don't know precisely how they work and whether we'd be able to bring her on. But the whole idea that somebody is they had this in the criminal courts, where people used to be told, well, you can't plead because you're too thick, you're mad, basically.
Yes.
And they changed that because it's obviously unfair. Right.
Well, Ezra Pound in America was kept in prison for 13 years and told he was incompetent to plead, and therefore he was locked up for no reason.
Yeah, I know, and what they do here is they take your baby instead, and they say you can't plead, you've got the official solicitor, and the official solicitor concedes the case.
Did this woman earn a living at any time?
No, to be fair, she's quite young. She's in her early 20s. She's not going to be a nuclear scientist, you know.
No, but I mean, she can hold a conversation.
She can hold
make decisions about her life.
But the judges, I made the point to the judges that, you know, she's made the case to you herself. If she can actually present a case in court, she clearly can instruct a solicitor. And
they weren't having it?
They weren't having it.
And how many judges were there in this?
Two. This is Lord Justice Wall and
in the original court, how many judges were there?
There was one judge.
Just one judge, so it was one person's opinion.
One person based on a psychologist who was part instructed by the local authority.
So you're against an impossible force, aren't you?
Another one where we got a big row with the judges was where a woman was given an IQ test in English, did rather badly, so she was told she was too stupid, couldn't instruct a solicitor. She doesn't speak English.
Well, I'd fail if it was in Croatian, for instance.
Yeah, I know.
Wouldn't you? I mean,
yeah, exactly. So the fact that she got an IQ of 50, which is pretty low, to be fair, isn't surprising when she can't understand the questions.
It's
dreadful, isn't it?
It's corrupt.
That was one in Birmingham. The system, corrupt, in my view, is corrupt because there are too many conflicts of interest, and there's a conflict of interest. You know, the lawyers, there's a conflict of interest because if they fight the local authority, they don't get instructions. Now, there are some very, very good lawyers. All right? I'm not saying everybody in the system is corrupt. What I'm saying is the system is full of conflicts of interest, and some people respond to those inappropriately.
Unresolved conflicts of interest.
Unresolved conflicts of interest. And the single expert system, the absence of a second opinion, is one of the biggest problems in the system. So you have an expert comes along. We had a report recently about a case. I was in court. Well, I wasn't actually in court. I was in the court buildings this morning. Mum is not allowed to look after baby in part because when she was playing with baby, she put baby on a mat with another baby, and that gave a risk of baby being scratched by the other baby. Yeah, I know. Look, it's mad, isn't it?
Well, I don't know what that woman who's got 7 or 8 or whatever it is going to do.
Well, I know that. Yeah, but that's America. We don't have to worry about that one. So.
No. Okay. So basically, if they want to get you, they're going to get you, and it doesn't matter what your competencies are.
I know. There was a solicitor who said to us, this is up in the northwest, that she didn't want to fight the case too hard in case they took her children. Yeah, seriously. And
so out of revenge, if you were a solicitor who did the right thing and stopped the machinations of the children's services at the local council...
That's her fear.
This lawyer was in fear, and she ought to know, shouldn't she? She ought to know, was in fear that they would then...
Take her children.
I
know, it's dreadful.
And this would all be in a secret court.
Let's take, all in a secret court where you've got great difficulty dealing with it because it's based on the opinion of a secretary, a single expert who is beholden to the local authority for their revenue.
So, why are these courts secret, John?
There is a good argument for privacy or secrecy up to a point. And the good argument is that they do talk about very sensitive things, all right? But that should not prevent the parties, the parents or the children, complaining about what's going on. Do you see what I mean?
But all courts are full of sensitive things. When you go up on a robbery charge, they talk about sensitive things, don't they? They talk about your nature and what you've done in the past and all these kind of things.
Yeah, but they go into the details of what happens within the family and all sorts of things like that. And it's only right that the parties should have some control over that, right? And what it is it's handling how we get transparency in is an absolutely critical thing because you need to get transparency in. You cannot have a situation where the parents are gagged from saying what happened to them. That's what's wrong.
But you are able to say about some cases, aren't you, now?
It's quite complex, and the law that's particularly useful to me is the 1688 Bill of Rights, Article 9. All right? I always find the best laws come from the 1600s because you've got habeas corpus, which was 1679, and the Bill of Rights, which was 1688 or 89, depending on how you see it.
This reminds me of my interview with John Harris, actually, the free man who talked about these laws as well.
They are actually very important because they allow me, through parliamentary proceedings, to bring things into the open that are otherwise not in the open.
So if, say you were a parent who suffered this injustice, lost your children, technically, as things stand, the court is in secret and you cannot discuss it. So in the court, they can all stand up and lie.
Yeah.
And you cannot discuss it with anybody except, what, your legal advisor?
Or your legal advisors and lay advisors. And you can't even tell your MP, in theory, what happened in the details of the court hearing. You can only give your MP a copy of the judgment. The judgment is very important. It is the judge's reasons for making the decision that the judge makes.
But if the judge's reasons